Hello, Mark Petro with the Petro Law Firm. Today I want to talk about the difference between a mediation and arbitration because I get this question quite often and I see that people are confused about the two. Have any questions about mediation or arbitration? Pick up the phone today and give me a call. But let's talk about mediation and arbitration. What's a mediation? A mediation is where the parties voluntarily get together with a mediator and try to work out a settlement of the claim. A mediator is usually another lawyer or a retired judge who acts as the mediator. And the mediator is just simply a neutral third party. The mediator does not rule on the case. The mediator is there as a facilitator to help the parties get together to see each side's weaknesses and strengths, to help you see your case that you just don't see it without somebody else telling you. It's kind of like a blind spot. An arbitration, on the other hand, is where by law, usually through a contract, for example, an automobile purchase agreement, the parties are required by the contract, by the agreement, that if there is a dispute that arises, that they both agree at the time they enter into that agreement, the contract, that they will, if there is a dispute, that they will have their case heard before an arbitrator. So an arbitration is binding where a mediation is not binding. An arbitration is binding by the findings of the arbitrator or the arbitrators. Usually there's either one or the three arbitrators in an arbitration. It depends on what the agreement was at the time the contract was entered into. So that's the difference between a mediation and arbitration. Mediation is voluntary, it's non-binding. An arbitration is required by a contractual agreement, and the parties are bound by the findings, the rulings of the arbitrator or the arbitrators. If you have any questions about mediation versus arbitrations, pick up the phone today and give me a call. Mark Petro with Petro Law.